Welcome to This Day in His Story, created by American Heritage Worldwide, a reminder that every day holds something new to learn. Did you know that the 14th Amendment became the foundation for many landmark civil rights cases, even though its promises were not immediately honored in every state? Learn that on July 28, 1868, the 14th Amendment officially became part of the United States Constitution and guaranteed citizenship to formerly enslaved individuals after the Civil War. Discover that today, the 14th Amendment continues to influence decisions involving civil rights, voting rights, education, and equal treatment under the law.
Welcome to our deep dive. So, I want you to start by trying a little thought experiment with me. Imagine for a second trying to rebuild a house while the structural beams are literally still on fire.
Yeah, that's a pretty intense image.
Right. But that was the United States immediately following the Civil War. In July of 1868, the country fundamentally rewrote the legal definition of what it meant to be a human being in America.
And it was not an easy process at all.
No, not at all. And to get that new definition on the books, the federal government actually had to force rebellious states to accept it, basically at the literal point of a bayonet.
Which is wild to think about today.
It really is. So today we have this really fascinating set of historical notes sitting in front of us, and they are all focused on one single massive addition to the Constitution, the 14th Amendment.
Yeah, the 14th Amendment, which, isn't just dry legal text. It is the absolute bedrock for civil rights claims in the U.S. today.
Right. And our mission for this deep dive is to figure out how this specific text completely reshaped American citizenship. Why did it require such intense political force to pass? How have the courts tested it? And ultimately, how does it reflect a much higher moral law?
It's a huge topic because when we look at the source material, you really see a document that was born out of a very specific, urgent crisis.
The status of recently freed slaves, right?
Exactly. They had an immediate need to resolve their citizenship status. But the framers, they chose language that created this profound structural shift. It wasn't just a quick fix.
Right. But before we get into the actual mechanics of what the amendment says, we really need to look at the environment it was born into. Because the notes here talk about a really messy ratification.
Oh, it's incredibly messy and hostile.
So the amendment was officially ratified by the required number of states on July 9, 1868. And then a few weeks later, on July 28, Secretary of State William Seward officially proclaimed it part of the Constitution.
But getting to that required number of states, that was the hard part.
Right. Okay, let's unpack this. Because I like to think of it's like changing the rules of a club and telling the members who just violently rebelled against the club that they absolutely must sign the new rule book if they ever want to be let back in the door.
That is a perfect analogy. The Union essentially forced the former Confederate states to sign it.
Wait, they were literally forced?
Yeah, the federal government made approval of the 14th Amendment a strict, non-negotiable condition. If a former Confederate state wanted readmittance into the Union, they had to ratify it.
Wow.
Because, the Union understood that they couldn't just trust the southern states to organically develop a sudden respect for civil rights, right?
Yeah, because their whole economy was built on slavery.
Exactly. The entire social and economic architecture of the South was built on subjugation. So waiting for a change of heart just wasn't an option. They had to mandate it legally.
But even with that ultimatum, looking at the notes, Louisiana, North Carolina, and South Carolina outright refused to ratify it initially.
Yeah, they looked at the terms and basically chose to remain outside the political system rather than accept the new rules of citizenship.
That is wild. They'd rather have no statehood than give equal rights.
It shows you how deep the national fracture was. But the Union declared the amendment ratified anyway. They just overrode the objections of those specific states.
Because they just couldn't stall civil rights any longer.
Right. The animosity was fresh, but the federal imperative to establish these rights couldn't be stopped by the people who had just fought a war to prevent them.
Okay, so if the resistance was that fierce-like, states willing to forfeit their political existence over this, we really need to look under the hood. What exactly were they so terrified of signing?
Well, the 14th Amendment is incredibly comprehensive.
Yeah, because we usually think of an amendment as one simple rule.
Right, like freedom of speech or the right to bear arms.
Exactly. But looking at the source material, this is essentially a constitutional Swiss Army knife. Along with the 13th and 15th Amendments, which are the Reconstruction Amendments, this thing has 5 distinct sections.
5 very powerful sections.
So let's start with Section 1.
Section 1 is basically the engine of the whole thing. It guarantees citizenship to anyone born or naturalized in the United States.
Which instantly changed everything.
Totally. That single sentence stripped states of the power to decide who gets to be a citizen. And then it goes further. It guarantees constitutional rights and forbids states from denying any person life, liberty, or property without due process of law.
I want to pause on due process really quick because we hear that term on TV shows all the time, but mechanistically, how does that actually act as a shield for you, the citizen?
Good question. Mechanistically, it means the government has to follow a strict, standardized sequence of legal events before they can take away your freedom or your stuff.
So a local sheriff can't just lock you up because he doesn't like you.
Exactly. A sheriff or a governor cannot simply seize your land or put you in a cell because of your background. They have to go through a transparent legal system where you can actually defend yourself.
Okay, makes sense. And then the text also forbids states from denying anyone equal protection of the laws.
Yes. And that right there is the genius of the text. It's the most crucial, broadly phrased language in the whole document.
Why does the broadness matter so much?
Because the framers didn't just write a statute outlawing, one very specific type of discrimination in 1868. They wrote a sweeping philosophical principle.
Oh, I see.
Yeah. By mandating equal protection, they created a foundation. If a state failed to protect its citizens equally, this clause gave people the right to seek help from federal courts. It set up civil rights claims for the next 150 years.
That is really fascinating. But then moving on to Section 2, it gets highly specific again. It guarantees voting rights to male citizens who are 21 and older.
Right. They were addressing the immediate reality on the ground. Newly recognized citizens needed voting power to protect themselves at the ballot box.
Which leads to Section 3, which takes direct aim at the people who caused the war. It basically forbids anyone who engaged in insurrection or rebellion from holding public office.
Yeah, it acts as a political quarantine.
And the notes define insurrection as a violent act to defeat and take over the government.
Right, because you can't have the architects of a violent rebellion immediately stepping back into Congress to dismantle the new system from the inside.
That makes total sense.
Right.
Okay, then Section 4. At first glance, this one seems like it belongs in, an accounting ledger.
It really does.
It says the federal government cannot be forced to pay debts incurred by the Confederacy during the Civil War. Like, why put unpaid war bills into the Constitution?
Think about the structural validation. If the federal government paid those debts, it would legally validate the rebellion.
Oh, wow. I didn't think of that.
Yeah, the southern states had taken on massive financial liabilities to fund their armies. By nullifying those debts at the constitutional level, they financially crippled the rebellion's backers.
And protected the national treasury.
Exactly. It addressed the literal bank accounts of the nation right alongside its soul.
Amazing. And finally, Section 5 gives Congress the power to pass appropriate legislation to enforce all of this. It essentially gives the amendment teeth.
It was supposed to, yes.
Right, supposed to. Because here is where I see a glaring disconnect in the notes. If Section 5 gave Congress all this power, why do the sources describe a reality on the ground where freed slaves were almost immediately stripped of their freedoms again?
Because writing a law and enforcing a law are two entirely different things.
So what did that actually look like for the freed slaves? How did local jurisdictions bypass something so clearly written in the Constitution?
This brings us to the really harsh reality of localized legal manipulation. The 14th Amendment established federal intent, right? But daily life is administered at the county and state levels.
Like local police, local courts.
Exactly. Local jurisdictions couldn't just rewrite the Constitution, so they exploited loopholes instead. They passed what were known as black codes.
Oh, right. I've heard of those.
Yeah, these were localized statutes specifically designed to bypass federal protections. They didn't technically say you can't vote because that would violate Section 2.
But they found other ways to oppress people. The notes mention they barred recently freed slaves from traveling freely.
Right. Imagine having the federal right to vote, but a local law says you cannot cross county lines without proof of employment, or you get arrested for vagrancy.
That's terrifying.
And they barred them from owning certain types of property, which prevented anyone from building wealth. But most critically, these local laws barred African Americans from using the court system to defend themselves.
Wait, if the courts are closed to you, then that whole due process shield we talked about is practically useless.
Exactly. You can't challenge an unjust local law if they literally won't let you inside the courthouse to make the challenge.
That is such a tragic gap between the text in Washington and the reality on the ground.
It was. States used their police power to trap people in a system that just refused to recognize equal protection. And because of that, the battleground inevitably had to shift.
To the Supreme Court.
Right. The only way to force compliance was to test the amendment at the highest court in the land.
And here's where it gets really interesting. Let's look at the timeline in these notes. In 1869, which is literally just 1 year after ratification, a woman named Myra Bradwell tried to use the new Equal Protection Clause to defend women's rights.
Her case is a perfect example of how quickly citizens recognized the power of this new language.
Yeah, she passed the Illinois law exam, so she was clearly competent.
Yeah.
But the Supreme Court of Illinois denied her a license to practice law.
Because the courts at the time were still deeply entrenched in old social structures, Bradwell saw equal protection and correctly understood it should apply to her.
But the court said no.
The court determined that as a married woman, she possessed no legal status apart from her husband. So they argued the 14th Amendment didn't protect her right to choose her own profession.
Oh, wow. So even when citizens tried to activate the amendment, the courts just refused to apply it correctly.
Often, yes. And that judicial resistance really reached its lowest point a few decades later.
In 1896, right, with Plessy v. Ferguson. And I really have to stop you here because I am genuinely confused by this piece of history.
It's a dark chapter for sure.
If Section 1 explicitly forbids denying anyone equal protection, how on earth did the Supreme Court legally justify school segregation? Like, what was the actual legal loophole they invented?
They invented a doctrine called separate but equal.
Separate but equal, okay.
Yeah, it was complete legal gymnastics. They relied on a very narrow, corrupted interpretation of the word equal. The court essentially argued that as long as the state provided separate facilities for black and white citizens, the technical requirement of the 14th Amendment was met.
But the forced separation itself is inherently unequal.
Completely. And it was obviously designed to maintain a racial hierarchy. It was a massive failure of the judicial system. They took this broad language that was meant to be a shield, and they allowed states to weaponize it.
And the most devastating part is that this wrongful interpretation stood for decades. Citizens had to live under this flawed understanding of their own rights from 1896 all the way until 1954.
Right. It took over half a century for the Supreme Court to finally correct the error in the landmark case of Brown v. Board of Education.
Where they finally struck down school segregation.
Yes. They ruled that separate educational facilities are inherently unequal.
Over half a century of delayed justice. But, the critical takeaway here is that when the correction finally happened in 1954, it happened because the 14th Amendment was still sitting right there in the Constitution.
Exactly. The text itself hadn't changed at all. The interpretation just finally aligned with the true meaning of the text.
Which points us toward a much deeper realization about this document. When we step back from the political arm twisting and all those agonizing court battles, we have to recognize what the 14th Amendment is actually codifying.
Yes. The source material is very unequivocal on this point. These legal frameworks, equal protection, and due process are really earthly reflections of fundamental moral laws.
Yeah, the notes make it clear that God establishes moral laws and expects us to uphold his commandments. And the 14th Amendment is deeply intertwined with these divine laws.
It is the absolute foundation of the text. When the amendment demands equal protection, it's acting as a legal tool designed to uphold the moral commandment to treat human beings with the dignity they are divinely owed.
That's a powerful way to look at it.
The laws of man, when they're actually just, are attempts to reflect the moral laws established by God. The 14th Amendment is this profound attempt to align our legal reality with that higher truth.
Right. It states that life, liberty, and property can't be stripped away unjustly because those rights precede the government itself.
Exactly. The government doesn't invent your humanity. It's merely tasked with protecting it.
Which brings the weight of this document directly to you, listening to this deep dive right now.
Yeah.
When you look at the incredible architecture of the 14th Amendment, born from the smoke of the Civil War, forced upon rebellious states, and tested through decades of court battles, in what ways do you see it upholding moral law?
It's a great question to reflect on.
Which of these specific freedoms do you think is the most vital to a functioning society? Is it the uncompromising guarantee of citizenship, the procedural shield of due process, or that sweeping mandate of equal protection?
Because the language designed to protect the most vulnerable people in 1868 is the exact same language protecting your fundamental rights today.
Exactly. Take some time today to share your thoughts on this with a family member or a friend. Because these aren't just dry historical events, these clauses dictate the active rules of the society you navigate every single day. So, to pull all these threads together, because we've covered an incredible amount of ground today, we started in the volatile aftermath of the Civil War, looking at how this amendment was essentially forced into existence to rebuild a fractured nation.
Right. And we explored the mechanics of its 5 sections: redefining citizenship, requiring due process, nullifying Confederate debt, and giving Congress the teeth to enforce it all.
And then we analyzed that stark contrast between the federal law on paper and the really oppressive reality of the black codes that tried to bypass it.
We traced the agonizingly slow arc of judicial interpretation, too, from Myra Bradwell's early fight in 1869 through the wrongful depths of Plessy v. Ferguson to that ultimate correction in Brown v. Board of Education.
And we grounded all of that in the understanding that the amendment ultimately stands as a monument of holding divine moral law.
I want to leave you with one final thought to explore on your own. The framers who wrote the phrase equal protection were trying to solve the specific, devastating crisis of 1868. Yet they had the foresight to use language flexible enough to correct the deep injustices of 1954. So, as we face the unique moral imperatives and technological challenges of our own era today, how might the 14th Amendment be called upon to protect the unseen freedoms of tomorrow?
Oh, that's a brilliant question.
Think about things like data privacy, or genetic rights, or digital spaces. What is equal protection going to look like 50 years from now?
That question really just proves the ongoing power of the text. The House is always under construction, but as long as we understand the structural beams of the 14th Amendment, we have the right foundation to keep building. Thanks for joining us on this deep dive. We'll see you next time.
Thank you for joining us for this day in His story. May the lessons of yesterday inspire you to see God's hand today and to play your part in His story now. For more faith-based learning, visit ahsworldwide.org, the homeschool for faith and family.